Good evening and thanks for joining us. We begin tonight with a seismic legal shift on an issue that could one day affect all of us. The Supreme Court has struck down the law banning doctor-assisted suicide. It means Canadians who are suffering unbearably at the end of life will have a choice about how they die. Polls show the majority of Canadians want that choice, and though the Harper government never wanted to reopen this debate, now it is being forced. Jacques Bourbeau will look at the politics of this in a moment, but we begin with Eric Sorensen and a groundbreaking ruling. Eric?
Donna, 22 years ago, the Supreme Court suggested we weren't really ready for this conversation. Though at the time, a poll said 77% of Canadians supported doctor-assisted suicide. More recently, a similar survey found 84% agreed, at least somewhat, that a doctor should be able to help end a person's life in some circumstances. So today, the court decided it's time we talk about how we die.
We did it, whispers the daughter of a woman who left the country to get help to die. The moment of truth for Right to Die advocates brought not joy, but relief.
It's allowed.
A landmark decision from the highest court in the country, and it was unanimous. The outright ban on doctor-assisted death deemed unconstitutional. It clears the way for the first time in Canada for physician-assisted death for a competent adult person who, one, clearly consents to the termination of life, and two, has a grievous and irremediable medical condition, including illness, disease, or disability that causes enduring suffering that is intolerable to the individual. What does that mean?
Is that Canadians who are suffering unbearably at the end of life will have a choice now. The choice to seek the assistance of a physician if their suffering becomes unbearable.
Kay Carter had to go to Switzerland to get a doctor's help to end her life. It was left to her daughter to hear the court's ruling in her case.
A huge victory for Canadians and a legacy for Kay. Thank you. Thank you.
Serious public debate began a generation ago.
If my doctors refuse to relieve me of my suffering,
Sue Rodriguez asked to die with dignity, but the High Court then said no, in part because people with disabilities could be discriminated against. What changed? The court this time could consider the experience of other countries. But members of the group Not Dead Yet say those with disabilities will still be discriminated against.
This court has decided that apparently that discrimination isn't important enough to protect people with disabilities.
No matter how you cut it, this says some people are better off dead and they can decide for themselves that they want to be dead, and we will give them assistance to help them kill themselves.
But generations of families and doctors who felt helpless now see hope to reduce suffering. The Supreme Court telling Canadians and lawmakers to start discussing how to do it. Eric Sorensen, Global News, Toronto.
It's a hot-button issue, and it's landed in the lap of Justice Minister Peter MacKay.
A very emotive subject, to say the least.
So what will he do? All MacKay will say, his government has a year to come up with a response.
The most important part of what Parliament will do is how we protect all Canadians' rights.
The Conservatives have opposed assisted suicide, yet, ironically, one of their own MPs has long argued for it. And Stephen Fletcher is thankful the Supreme Court has broken the logjam.
Parliamentarians would rather have their eyes scratched out than deal with this type of issue.
Fletcher says it's time for MPs to craft a new law, and they could simply vote for a bill Fletcher's already introduced. It lays out the conditions for physician-assisted death. You'd have to be 18 years old, have an illness, disease, or disability causing intolerable suffering, and 2 doctors would have to be involved. But some of Fletcher's colleagues are leaning in a different direction, not ruling out defying the court to keep assisted suicide illegal.
There should be supremacy of Parliament, so I'm not shy about the notwithstanding clause.
On the opposition benches, they know something has to be done They're just not sure yet what that is.
I think it's something that we should explore if it's going to help to make things clearer, less ambiguous.
And that's exactly what Canada's doctors say is needed. They'd like a new law clearly spelling out what doctors can and can't do.
Physicians are going to want to know exactly what type of patient would qualify for these services. So we've got some direction. We probably need a little bit more.
The other big issue is timing. If they want a new law, MPs have a year to come up with one. And with an election coming up this fall, that doesn't leave them a lot of time. Donna?